Greetings, everyone. Wishing you all happy holidays. I hope everyone is doing well. We are to touch base. There we go. All right. Happy holidays, everybody. I hope everybody is doing well. I think that it is, super important toward the end of the year for us to just, reflect on everything that has, taken place over the past year and kind of consider what we are ought to expect going forward in 2026. There has been obviously a massive change in the administration since January 20th, and that's brought about substantial changes to the overall picture of immigration in the US. No doubt about it. There's been considerable impact upon folks who are, foreign nationals residing in the US seeking to become permanent residents and eventually citizens. And that process has become more challenging and definitely requires greater thought and strategy in terms of how we approach the situations and scenarios that arise. So, just kind of thinking about that overall picture is super important. And at the same time, I think we have seen certain, I would say, like advancements in very like minor areas. So, I think just the past few weeks, we've seen, the new bulletin for January come up here. And I just want to pull it up because a lot of folks, I think, tend to not really know how to read these bulletins, unfortunately. So you're all familiar that the, State Department issues a visa bulletin that is, issued on a monthly basis. So this is the visa bulletin for January 2026. However, our audience, most of you are in the United States and are seeking to adjust status, filing what's called Form I-45, adjustment of status, and that's a whole process that's become a lot more complicated than it used to be. So I definitely suggest anybody who is going to apply for adjustment of status, reach out and think about what we are going to put forward as it relates to adjustment of status, because there are some new requirements there. But when we decide the timing as it relates to adjustment of status in the United States, whether you are on an EB2, EB3, or seeking EB1, we have to understand that the bulletin that is issued by USCIS, or I'm sorry, by the State Department on a monthly basis is not necessarily the authoritative information that we all think it is. So, they issue final action dates for the employment-based preference categories, and those are issued here. And then they also issue what are called filing dates. So that pertains to one who is outside of the US and they need to determine whether or not they're able to file or apply for a visa. And then the final action date is what determines whether and when that visa is to be issued. Now, for individuals who are physically present in the United States, you have a completely different chart and information. Now, that information is pulled from the State Department bulletin, but USCIS, Department of Homeland Security, makes a determination as to whether or not your date is ready for adjustment of status based on the availability of visas and whether they want to use, for the purpose of adjustment of status, consideration of adjustment of status, the filing date or the final action date. In some instances, they will use final action date to permit one to file for adjustment of status. On the other hand, they might determine that they want to use filing date for the determination of one's ability to file for adjustment of status. So let me be very clear. The issue that you want to pay attention to is, what does USCIS publish as it relates to when to file your adjustment of status? You don't want to depend solely upon the State Department bulletin, because they will determine, USCIS will determine whether to pull from filing date or from the final action date. And that could change from a month-to-month basis. So we do see the December 2025 bulletin that is, in force presently for the next, a week or so. And it had, for example, under first category, the India filing date for adjustment of status as April 15, 2023. So really quick, if we look at the visa bulletin for the filing date here, they took August 1st, 2023, right? So when to file was based on the filing date for last month. And it is so for this month as well. So when we look now at the adjustment of status date for January 2026, so those of you who will be filing in January 2026 are looking to file, the date has moved up to August 1st, 2023. August 1st, 2023 is your new filing date starting in January for first category. So that means if you have an EB2 or an EB3 that precedes August 1st, 2023, we can port that date into the EB1 category and file, and you would be eligible for adjustment of status. Second category has gone to December 1st. That's, I think, the same as it was. Yep, same as it was in December. And third category is actually August 15, 2014 for India. And that is also an advancement. And so China advanced January 1st, 2022. Previously, it was, a 1 month advancement there. So we see the importance of understanding what it means to read the bulletin in the proper way so that we know exactly how to approach the date for adjustment of status, right? So that's a very important point. And anybody who is thinking about filing for adjustment of status, there are new provisions, particularly as it relates to the public charge rule, that you need to pay attention to. I would strongly advise having a consultation and knowing exactly what you're getting into before we, proceed in that manner. Now, probably, just thinking about, I think overall the adjudication up until now for the 2025 going into 2026, as it relates to EB1A, there's been a lot of reporting, a lot of, attorneys have been sharing posts and such, and LinkedIn and other forums about, increases in, RFE or denials and such. And there certainly has been a tightening of scrutiny as it relates to evidence that has come across. There was, I think, a very important period where we did see a lot of pushback from USCIS as it related to some of the sort of superficial kinds of evidence that are being put out there by applicants. So, you're probably not going to want to sort of, advance such, evidence such as, Globee Awards, Stevie Awards. We've spoken about this ad nauseum, and making sure that folks, understand the, benefit and risk and can weigh them properly as it relates to those, situations. One thing I think that is really important to touch upon, I think a lot of you are well aware from, paying close attention to what's happening in terms of, EB1 and national interest waiver adjudication and regulations, that the administration has sort of announced that they will, in fact, they have announced that they will put forward new regulations as it pertains to self-petition categories. And, that will probably appear in a federal registry update January 15th or 16th. And you have to understand that those changes are somewhat limited by case law. So you probably won't see any major changes as it relates to framework. However, some of the examples of acceptable evidence could be tightened up. Now, what I have seen, and I think the most probable situation, is you will see a sort of reversal of some of the Biden era favorable updates. So, for example, there was a update as it related to other comparable evidence under the Biden administration that allows one who is, seeking EB1A to present evidence that is more consistent with their specific area of endeavor and the industry that they're a part of, rather than provide evidence of, for example, publications for one who is not an academic. So if, for example, you're an industry related contributor and you are applying for EB1A, what the regulations say at this moment, and this was a change that came, under the Biden administration, is that publications might not apply to one who is an industry-related contributor. Therefore, that individual can present other comparable evidence, such as, for example, participation in a trade show, as evidence that they are participating or involved in work that is at the top of the industry or at the highest level of the industry. So that's comparable to something that an academic would do with regard to publications. Now, you have to understand that there is important case law called Kazarian v. USCIS that was decided, and it would likely constrain or put constraints upon USCIS and how they may, apply regulations to EB1A, because the two-part test laid out in Kazarian specifies that the administration must go through a process where they determine sustained national or international claim according to the 10 regulatory criteria that we are all familiar with. That is to demonstrate that you have original business or technology or scientific or academic related contributions of major significance, that you perform in a critical or leading role for a distinguished organization, that you command a high salary or other exceedingly high remuneration in comparison to your peers, that you review and judge the work of others, that you have professional membership in an organization that requires outstanding achievement of its members, that you've authored scholarly work and received lesser national or international awards, that you've been discussed or mentioned in the media. And then the other criteria relate to commercial sales for one who is involved in like a concert or venue, like, for artists and such, and whether their artistic work has been displayed at a showcase. Now, those 10 regulatory criteria will remain. However, the examples of evidence that are permitted within them will likely change, and you might see some, sort of tightening up. Now, here's the caveat to all that, and I think this should probably give folks a little bit of sort of ease as it relates to the situation, and that is when the changes are presented to the Federal Registry, those changes are subject to a 30 to 60 day feedback or review period before they are implemented. And once they are implemented, you can, bet a dollar to a donut that there will be significant litigation in terms of their interpretation and, how they might work. So you probably are not going to see substantial regulatory changes directly impacting adjudication for an extended period of time. And to the extent that those regulation changes are put into place, it is, likely that they will be substantially limited by, existing regulations. I think that a lot of this strategy arises out of the desire of the administration to sell its so-called Trump gold card. So that's another topic that is sort of, interesting. And, we could kind of see that the, Trump gold card situation is not selling like hotcakes, because it's actually already available. So they did create a form called I-140 G for gold. And essentially it requires one to demonstrate that they have the funds available. So you have to have $1 million for per applicant. If you're a family of 3, all foreign nationals, then it would be $3 million. If it's a company-sponsored I-140G Trump Gold Card, it's $2 million per individual. And one must pay a $15,000 application fee to USCIS, demonstrate that those funds are available, provide the, demonstrate the, chain of ownership of the funds, like what is the source of the funds, for example. And then, you would be theoretically, and essentially the form, what it does is it asks you to select either EB1A or EB1 category or EB2 NIW. So essentially what they're saying is payment of $1 million gift to the US government is evidence of either exceptional ability under EB2 NIW or extraordinary ability under EB1A, and therefore your I-140 will be approved upon payment. Now, the caveat to that is this will also face significant litigation because the regulations, and not only the regulations, the statute itself that created the EB1A category specifies that one must demonstrate sustained national or international claim that is recognized within their industry. They need to demonstrate that they will substantially prospectively benefit the US and that they will continue to work in their field of endeavor. So it's hard to sort of reconcile those statutory, congressionally mandated requirements with payment of $1 million. For example, if one inherited $1 million and is willing to gift that to the United States along with a $15,000 application fee in exchange for a green card, they probably have not if it's an inherited amount, let's say the person just turned 18 or 21 years old, they might not have a track record of sustained a claim. So this is probably something that would be challenged. And I think, it's something that could undermine the regulatory criteria. And then what happens 3 years from now when we have a new administration and whether these things will be honored and how they'd be looked at. So there, I think, is a cloud of uncertainty that will prevent, enormous sort of, acceptance of this as a means to a green card. And probably I would still advise that one look at, if they are willing and able to, spend that much money on a green card, they're probably better off looking at an EB5 scenario where an investment in, that range of amount would, result in acquiring a green card through that process. And you'd actually, still see that money at the end of the day. Whereas, with the Trump so-called gold card, it's more probably going to, you have a cloud of gray over the actual benefit itself. And on top of that, it might be, it's definitely money that you'll never see again because it's a gift, it's a payment to the government. So that's something that is, really, really important to note. I think at the same time, we still are really looking at a scenario where we have seen a lot of fair interpretation of regulatory criteria throughout the year. There has been a lot of success in, filing EB1A. National interest waiver did see definitely a drop off in approval, but I think that was mostly related to establishing that one demonstrate that they have a proposed endeavor that is of national importance and providing specificity around that proposed endeavor rather than saying that the endeavor I'm involved in on sort of macro scale is beneficial to the US. What we needed to do is say that the endeavor that I'm specifically engaged in is beneficial to the US. So that kind of, I would say strict, plain language of the regulation interpretation of the statute and of the regulations is going to, go forward. So as long as you know how to position your case as it relates to those matters, then you should be fine. I did also want to discuss, I think, more broadly, kind of how USCIS might be limited by certain regulatory changes that the government will be attempting in the coming year. One of the Biden era advancements or adjudication updates that took place, which the government is probably going to try to reverse, is the idea that one may be involved in contributions that were done as part of a team, right? So where one has done contributions that are part of a team, this has always been the case that it was acceptable evidence under the USCIS regulations and adjudication process. Under the Biden administration, it became explicit, meaning the regulations were updated to reflect what was reality. And the reality being that one who has made contributions to, whether it's to their employer or to the field generally, can do so within a team. So we saw a regulation update that, for example, stated where one receives a award as a member of a team, this can be proffered or presented as evidence for, EB1A or what have you. And, this is going to be something that is going to be attempted to be limited in the coming period, right? However, I wanted to kind of think about this as it related to the law and what exactly is going to be allowed, because and I sort of put together this concept of basically critical role does not require working alone. So how team-based contributions satisfy USCIS standards, and sort of addressing this misconception that EB1A cases, a person must have worked alone or exercised formal managerial authority to qualify under critical role criteria, for example. And this misunderstanding leads to, I think, people who are otherwise strong candidates to maybe, not necessarily put their case forward because everything that they have done has involvement from other people. Well, I mean, I don't think that there's any serious technology or business or even scientific or academic contribution that exists without more than one fingerprint. It's impossible that one would have such a sort of exclusive contribution. And I think that part of the anti-immigrant sentiment and forces that are out there that are trying to figure out sort of underhanded ways of limiting access to a green card through the EB1A category is going to try to sort of present this as a means to do that, to say that, hey, if you want to present a contribution as evidence of your extraordinary ability, you need to show that this was only your contribution and that it's your work and no one else's. And that is actually something that is contradicted by law. So, for example, if we just look at the regulation, right? It says that a petitioner may satisfy EB1A by showing that the beneficiary has performed in a leading or critical role for organizations or establishments that have a distinguished reputation. And the idea here is that if one is advancing work that is significant importance to the outcome of an organization's activities, they satisfy the requirement of critical role, meaning where work you have done is significant to the outcome of the organization that you're performing for, and that organization has a distinguished reputation within the area that you are performing, it means that you have risen to the highest level of the field because this organization that is distinguished within your field is trusting you to undertake work that is at the highest level of the field, therefore putting you at the top of the field as it pertains to the Kazarian analysis that was established under the federal court decision. So noticeably absent from the regulation are any requirements that the beneficiary work independently, was the sole contributor, managed employees, held executive authority, so on and so forth. So teamwork does not defeat a finding of critical role. And I collected a number of AAO decisions and even federal decisions that reflect this principle. So in June 7th, 2016, the USCIS found a critical role where beneficiary architected and drove core technical programs relied upon by a distinguished organization despite the involvement of large teams. 2017, the appellate division of USCIS explicitly rejected the notion that collaboration precludes a finding of critical role. right? So this is again and again and again. 2019, recognized critical role based on strategic influence and organizational reliance, even though the beneficiary did not exercise formal managerial authority. So these decisions reflect consistent framework that has over and over and over again been established by law. And the reason why the appellate division of USCIS, and I intentionally picked cases during the initial Trump administration, the reason why USCIS is unable to find the decision any other way is because there are federal court decisions that establish this particular rule. So first of all, Kazarian, the most important case under EB1A, states that unilaterally USCIS cannot impose novel substantive or evidentiary requirements beyond those set forth in the regulations. And then there's a case, Rijal, which essentially provided that discounting expert testimony, must remain tethered to regulatory text. So again, saying that you cannot go away from the established text as it relates to the requirements, and that essentially eligibility is established by preponderance of the evidence, not by proof of exclusive or singular responsibility. And that was another important decision. So these cases are particularly important because USCIS sometimes conflates the idea that one is making important work to advance the organization's activities with one who is irreplaceable, right? And the law doesn't support that. So critical role does not mean irreplaceable. It means that the work that you have done is significant to the outcome of the organization's activities, right? So, we go on, and I encourage you all to check this out because I think it's super important. Share it with your friends because it gives you a lot of good feedback on not only the critical role section and the fact that it can be established whether or not you work independently. So if you work as a team, the work that you do as a team can be used to support your claim of critical role. But that principle also applies overall to the USCIS framework. So this is, really something that we urge you all to, understand. And, if you're interested in putting forward your case in this regard, definitely now's the time to do it. And we could, certainly take advantage of that. So that's really important. The other thing that I think a lot of, I would say probably the biggest change that happened in 2025 is the use of artificial intelligence by folks in terms of preparing their cases, the widespread use of AI, and how this impacts adjudication. How does this impact case preparation? And I think that it's interesting because I see that the quality of um work that is being provided by folks is actually decreasing despite the amazing tool that is provided. So what it says to me is that it is likely the case that folks just do not know how to formulate testimonial letters and understand what USCIS actually looks for. Like if you're just typing dear chat GBT, prepare a critical role letter for me that I, perform in a critical role at Microsoft, I'm sorry, it's going to be trash. Like what you're presenting is garbage. There's a lot more that is going to go into it. Sometimes it actually takes longer than just writing it yourself because there's so much refinement that is needed with what is produced. Although a well-refined letter that is, I think has sort of human oversight with that legal lens and framework can be really powerful, but you really need to know how to put that, forward. So understanding that, letters should not be the cornerstone of a successful case for EB1A, first of all. Like you need to corroborate your letters with actual documented evidence. So you can generate whatever text you want. It's totally irrelevant. It does not matter. It will not help you in any way whatsoever getting your case approved. I promise you that. What matters is actual documented evidence, because anything that you present in the form of a testimonial letter must be corroborated with actual evidence in the record. In fact, I wasn't planning on doing this, but let me just kind of go back to our friend, the USCIS adjudication manual as it pertains to EB1A. And if you look, the first thing it says right here is that you need to demonstrate sustained national or international acclaim through extensive documentation, not through letters alone, right? So basically, understanding the first principle is that letters alone should not be the cornerstone of your petition. That needs to be a mindset when you go into developing your evidence. And that's the mindset we use at Silmi Law when we're approaching this. We want to make sure that we are putting the foundation of the case in actual documented evidence and preparing testimony that can be corroborated by actual documented evidence. And USCIS first principle does not assign value to testimonial letters simply because they are positive or are written by senior individuals. Officers evaluate who is writing, why they are qualified to assess the beneficiary, and how the letter supports the framework of EB1A eligibility. Letters that merely restate a resume or offer generalized praise rarely impact the outcome of a case. Why is that? Because you don't need to repeat things that can already be shown. Like, I don't need a letter to give a chronological sort of explanation about an individual. Let's say I work with somebody who's applying for EB1A, they ask me to prepare a letter for them. I'm not going to tell you their life story. I'm not going to write a biography about the person whom is seeking EB1A. Rather, I'm going to present testimony based on personal knowledge. What do I know that this individual has contributed? What is the relevance or importance of that contribution to the outcome of the organization's activities? That is what can be presented from one who works with the person. If somebody does not work with you, if you have never worked with them, and there's they're outside of your circle of professional acquaintances, that becomes someone who's independent and they can provide testimonial evidence. However, it cannot be the case that one who works with you provides testimonial evidence that is opinion-based. It should be personal knowledge-based. Somebody who does not work with you can express an opinion. So multiple letters from closely affiliated colleagues are less persuasive than a smaller number of well-positioned independent testimonials. However, independence alone is insufficient. The writer must also be credible. All right, I'm going to give you guys a gift. All right, I don't celebrate Christmas. You probably don't celebrate Christmas either, but I'm going to give you a gift anyway on this Christmas Eve. And that is, if you want to know whether a person is credible, you need to make sure they are visible. What visibility means is that you can find them without depending on LinkedIn. All right? Merry Christmas. The letters must align with the, consistent theory of the case, so that basically testimonial letters need to be strategic. They're not interchangeable. So meaning, like, the person's perspective needs to be appropriate for the testimony that they're providing. And it needs to be supported, right, by actual evidence, as we mentioned. So they shouldn't cover everything. They should be from a particular angle or particular perspective. The tone and structure of the letter need to be like appropriate for the purpose, right? Don't be like exaggerating. Superlatives are appropriate for holiday parties. They're not appropriate for EB1A letters, right? So let's not get into those either. A tailored strategy is essential. There's no universal template for EB1A testimonial letters. Appropriate structure, who the perspective is, the content, it depends on the petitioner's profession, their perspective. It depends on the overall strategy of the case, right? So basically, something actually might be beneficial to one person and harmful to another. You need to sort of reconcile those things. And if you check this out, there are some frequently asked questions that I address about testimonial letters. So these are two new articles I definitely encourage you to share with your circle of friends and folks in the that are thinking about applying for EB1A. So ultimately, I think that there are changes and we need to adapt to changes. There are things that are making the situation better. There's things making it worse. The last thing I'll say, those of you who are on H-1B have experienced pressure in 2025 that we did not foresee. I think that it has gone beyond what anybody would have deemed likely, particularly as it relates to the recent impact on those who have been, traveling abroad to visit family or, visit parents and the like, and have had their, appointments um, for stamping canceled, delayed by 4 or 5, 6 months. When, as you all know, there's, life to be had, and one spouse might be overseas visiting their parents, the other's in the US taking the kids to school and working in their job. And this kind of disruption is just, extremely harsh, and I think causing a lot of pressure on folks. And those of you, like many of our colleagues who are, many of our clients and colleagues indeed are who are extremely successful in their professions, those of you who have done everything right and are being punished under this draconian government policy, know that you can definitely reach out to us. We will stand firmly by your side and make sure to protect you in every step of your immigration journey. Um, Having said that, it is important to consider what other options exist, right? So if you don't have the perfect profile for EB1A, I think that you still should reach out, because we can consider a different path for you, such as an O1A under either a petitioning organization or even a self-petitioning O1A. It's a bit more complex, but we can go that route as a precedence for applying for a future EB1A. It does remove a lot of the uncertainty about depending on maybe an employer that that it might be a little bit sensitive in terms of how you're able to, or lack of flexibility. Whereas, maybe a more closely held company that sponsors your O1A might be more flexible, and you might be able to maneuver more smoothly, even, for example, working under a contract that this, closely held company has with a larger organization. That can be an option for O1A. The other thing about O1A is that your spouse would not be eligible for H4 EAD if you have a previously approved I-140 in EB2 or EB3 category. However, I think that it is important to seek O1A for one who has maybe a somewhat of a mediocre or less than perfect EB1A narrative. It might be a great way to establish that precedence of qualifying for extraordinary ability before proceeding with a I-140 EB1A case. So that sort of precedence can be extremely helpful as you file for EB1A. So let's think about that route: O1A first, then EB1A. I think if you are, you and your spouse both have H-1B, perhaps one can keep H-1B, one can go to O1A, and then from O1A leverage to EB1A. That's probably a good way to do it. And then those of you who are on H-1B, who are working for very distinguished organizations, earning over $500,000 plus, and you have not yet filed for EB1A or started to prepare your EB1A, you're just way behind, and you need to get your act together and contact us, because I'm sure that we can find a pathway for you. Very, very high earners, this is an objective measure of establishing that you are at the highest level of the field. It's one of the best mechanisms. And I can, find that one who is in that sort of earning level is also going to have plenty of evidence that they are making a important impact on the outcome of their organization's activities. They probably have other comparable evidence, original business contributions. So we can, reviewing and judging the work of others, so on and so forth. So anybody over, 500,000 per annum, and you're thinking that you don't qualify for EB1A, you're probably just really misinformed and are reading the wrong stuff. So reach out, we will help you. It doesn't mean that you need to have that in order to qualify, but I think, just for those who, do have that level of earnings and have not understood yet that they do qualify, it's something we can absolutely help you with. So, with that, I think, I just wanted to wish everybody, safe travels and, a wonderful holiday, a happy new year. And, we are very, very focused on outcomes for our clients. We've had a lot of success with delivering approvals. We've had some, minor setbacks at times, which we, keep working to overcome with specific cases. Probably, this year a little bit more than last year. So that's, something that we have to expect, but it's not something that we are resigned to, right? It's not something that we find to be really dramatic. I think, probably, going from, 93 to 94% approval to 86 or 87% is not, gonna be a huge deal. You're gonna have to refile a little bit more at the end of the day, or, respond to more RFEs because of the sort of, scrutiny that's being applied. And also because a lot of turnover, meaning you have new people coming in that do not have the training that some of the previous adjudicators had. So that's also going to impact adjudication, probably more so than top down. That bottom up impact is more, I think, specifically impactful to most cases. But at the end of the day, we are definitely by your side moving forward in a very aggressive way. Many people have reached out for help with naturalization who've been approved for EB1A over the years, and we've been helping with those naturalization cases. So that means they've had their EB1A and adjustment of status approved for more than 5 years, and now we are applying for citizenship. We're applying for green cards, and of course, applying for new EB1A, national interest waiver, O1A cases, and anybody that needs help with family members, with any humanitarian related matters, we're always here to help. Please reach out at silmilaw.com. You can email us. You can schedule a free consultation for 15 minutes with a staff member, or I can also consult directly with you for 30, 60, or 75 minutes if you are daring enough. So look forward to hearing from everybody, and take care. Good night and Happy New Year.